Hello, everyone. My name is Cathy Tracey, and I am a member of Miller Johnson's education team. I am going to go out on a limb and guess that most of you did not spend the last moments of summer reading through the 324 pages of proposed Title IX regulations. So my job here today is to make it easy for you. So as you all know, in 2020, the Trump administration issued the first ever formal regulations related to sexual harassment. The driving force behind those regulations was really a concern that Title IX was being administered in a way that deprived respondents, mostly boys and men, of their right to due process. When the Biden administration took over, they promptly directed OCR to launch a quote unquote comprehensive review. Under federal law, there is a rulemaking process that requires the government to give the public notice of the proposed rules and the opportunity to comment on them. Needless to say, there is no chance that we're going to be living with those during this upcoming 2022-23 school year. So now I'm just going to highlight some of the major changes that I saw when I went through the 324 pages of documents. This new regulation specifically prohibits all forms of sex discrimination, including discrimination based on sexual orientation and gender identity, pregnancy and related conditions, and the like. The new regulation also broadened the definition of what they call sex-based harassment to cover all forms of sex discrimination, and it lowers the bar for what constitutes a quote-unquote hostile environment. The new regulations also added new explicit protections for students and employees related to pregnancy. One of the major changes is that when a student reports to the Title IX coordinator that they're pregnant, there are going to be specific notification requirements of what those students' rights are. One of the most significant changes under the proposed regulations is that it would extend Title IX to off-campus conduct. The new proposed regulations would eliminate all of the mandatory dismissal requirements of formal complaints. So as you may recall, there was a requirement that Title IX coordinators dismiss any complaints that were, for instance, of off-campus conduct because it was outside the program or activity of the school. And any complaints that on their face, even if you believe that they are true, do not rise to the level of sexual harassment. Those were all mandatory dismissal. Under the proposed regulations, it would be a permissive dismissal, not a mandatory one. The proposed regulations would require that we designate confidential employees, and those would be folks who a student or an employee could go to report that they had been subjected to sexual harassment and receive support, but not necessarily go through the formal complaint and grievance process. The proposed regulations remove the requirement that schools have actual knowledge in order to trigger their duty to respond. I think where they're trying to go with that is that schools are going to be expected to take more proactive measures to ensure that they are providing an environment free of sex discrimination. Another significant change relates to the informal resolution process. So under the current regulations, informal resolution is not available until a formal complaint has been filed, either by the complainant or by the Title IX coordinator. Under the proposed regulations, the informal resolution process could be offered at any time, even before a complaint has been made. The proposed regulations also more clearly set forth what the Title IX coordinator needs to do whenever they receive notice of conduct that may constitute sex discrimination. Another significant change is that the decision maker can now be the same person as the Title IX coordinator or the investigator. Under certain circumstances, supportive measures can burden the respondent. There are some limitations. They can only be imposed while the grievance procedures are ongoing, and they have to be terminated at the conclusion. Finally, the respondent would be entitled to an immediate appeal and review of the decision to whether it be a removal or some other burden to the respondent. Another significant change is that under the current regulations, there are provisions where both parties have a right to appeal under certain limited circumstances. Under the new regulations, it appears that the only right to appeal is when there has been a dismissal of the complaint. Finally, under the current regulations, there are specific training requirements for the people who are involved in the Title IX process. The proposed Title IX regulations would require training of all employees. I would encourage you to provide comment if you heard anything today that you either want to provide some support to the administration for, or if you have any concerns about that. Thanks for joining me today, and I hope you have a wonderful start to your school year.